Welcome back to the Oxford University Scientific Society for the second time this week. I hope everyone has enjoyed the previous session where we interviewed Dr. Higgins from DeepMind. Today's event is slightly unusual in the sense that we will not be hearing from someone working in science, but rather in law. Our speaker today is Mr. Herbert Swaniker from Clifford Chance, one of the preeminent law firms in the UK. He is going to talk about the implications of advanced technology on the practice of law. Be prepared to learn something new today. Do post your questions to the comment section as usual, and we'll read them out towards the end of the event. Without further ado, let's welcome Herbert.
Thank you very much, Luna. I'm very humbled and totally delighted to be speaking to the Society today, and thank you for those that have joined to hear this session. I'm Herbert Swaniker. I'm a technology lawyer at Clifford Chance, which means that I advise companies and people on legal and commercial risk relating to technology. So today we're talking about AI, data and facial recognition and the ethics and law around that. And my interest in this area stems back to the late noughties when I was studying and doing research in philosophy and looking at the ethics of technology. And since then, I've seen how technologies like facial recognition can be deeply misused and put minority groups, for example, at disadvantage. Technology use can be extremely invasive as well. You know, we all see stories about diversity in tech, but also about algorithms mischaracterizing people like me because of poor data that isn't representative and without appropriate legal and ethical risk assessments. I also read about data enforcement decisions. So for example, in the UK, we had what was called the gangs matrix, where people were profiled by the police and their livelihoods and reputation were put at risk because of the way that technology is used. And transparency and making the use of technology more clear is really important so that people understand how and why their information is used. So before we dig in, I'll be extremely clear. Technology is one of the most rewarding and important underpinnings of the society that we live in. And as a society, we often really overlook the huge benefits. So for example, if you design a program to help select the soundtracks, to your day, or when technology tells us what groceries we're missing, creating an entire gig economy and augmenting how we work and share our lives with people that we care about. But I've lived in a society where technology wasn't so advanced. Trying to dial into the internet and literally jacking in a cable at the back for the modem to make sure that I could play a game. I grew up in an age of innocence relative to now. And it means that I see tech risk and the law as so important to help prevent the deep harm that can be created by all of the sorts of technologies that you'll be creating. And so today we're focusing on the practical aspects of the law. I'm sure many of you are glad that you're not going to get a session reading out section numbers. But I really hope that you get to take away what the sort of legal and ethical expectations are that are falling around the sorts of technologies that you're creating. Because if we get it right, we'll all be at an immense advantage globally. So thinking about data and privacy first in particular, what's the legal and regulatory environment around that now? Well, I think it's clear that our thoughts, our behavior and sentiments have moved from being controlled and stored in our heads alone. They're now transmitted into the world through our fingertips, voice notes, comments, likes, collections of data points that essentially reduce identity to the sum of data that we put out into the world. And that is really interesting because looking at this slide here, there's been a power shift almost in imperceptible ways. Governments and regulators are recognizing that uplifting laws that regulate the use of technologies is incredibly important to make sure that power balance is reshifted in a way that's fair. And so you may have heard of the leading tech ethicist, Dr. Carissa Willis of Hertford College at Oxford, who wrote one of my favorite books of this year, Privacy is Power. And there's a quote that really stayed with me in the book. Carissa says, "From the moment you check your phone in the morning, you are losing privacy. Corporations around the world are recording what time you woke up, where you slept, how well you slept, and with whom." And for me, that really captures the reality of data and privacy ethical risk in the digital age. I think of the health apps that track when I sleep and help set my alarm to wake up at the best time. And that's fantastic and that's great, because at least I feel that I understand how my data is being used. But one of the issues that's been cracked wide open in recent times is what's not known. And that's one of the areas we'll focus on today. I think writers like Shoshana Zuboff have written about this and called it surveillance capitalism. Basically, essentially, where structurally personal information is capable of being used as a raw material to influence behavior, to influence societies and also modify behavior. And that is what's really catalyzing these new data protection laws that seek to protect information. So we've spoken about datafication and all of these data points being collected up, but what really changed the whole program around the laws around the world? Some of you may have heard in 2018 about Cambridge Analytica. Cambridge Analytica was found to have misused personal information from Facebook profiles of around 87 million US voters without their authorization. And that information included names, location information, email addresses, details of the likes that people were making on the platform. And it was gathered through a personality app accessed through Facebook by around 250,000, I think, individuals. And the data of their Facebook friends was then used to build a system that could target people with personalized political advertisements through the 2016 US presidential election. And just pausing there, you know, this is something that as computer scientists, you may find yourself in the position of having to be instructed to do if you're working for a company or you're a consultant and you're being asked to design a program. And, you know, what Cambridge Analytica revealed is that there is a cultural expectation, certainly, that people should understand these kinds of influences on their behavior. And back to what I was saying about Zuboff, this surveillance capitalism. And when Cambridge Analytica became known, there was this huge culture shock. People weren't aware of the scale of these activities and they didn't feel in control of their information. And as a lawyer, I can work with and help nitpick whether or not the right legal notices were in place. But the reality is that people don't feel well informed and they don't feel empowered by technology. And when that happens, when there isn't this ethical underpinning that reflects the societal norms, projects don't get off the ground and you lose trust of the people who the technology is meant to serve. You know, many companies share user data with third parties, and you will be asked to partake in these sorts of programs. And what the law is expecting, which we'll go into in a little bit more depth, is that you think through the issues to be able to make sure that you mitigate risks and harm to individuals. I think for me, the one thing that is extremely clear across all of the emerging laws is that having a no accountability framework is absolutely unacceptable if technology is to help rather than hinder society. So yeah, I mean, returning to the concept of privacy and power, you know, that Dr. Valise's book explores so satisfyingly. This alleged transparency gap with Cambridge Analytica meant that people found the power dynamic unfair, and that technology wasn't trustworthy. And so again, just to emphasize, even with all of the technically appropriate messages, the law and people expect more. I think one thing that's really useful to actually dig into a little bit is what is personal data from a legal perspective, because I think we all have our own understanding and assumptions, but legally, just understanding what the definition means is incredibly important in terms of your projects and things that you design, because then you know what frameworks you have to operate within. In short, personal data is when information that directly or can indirectly identify someone. So that could be a like on a platform. It could be an IP address if it makes somebody identifiable. So it's a very soft trigger. I suppose a voice note, you know, I mentioned before, is yours. It's personal to you. Your political views are yours. They are also personal to you. Your keystrokes when you pause a video, your credit card information, all of the really obvious stuff is yours. It's your information. And nobody else is performing these acts. And so it's very clear that that's your data. But one thing that you'll come across a lot is, when designing an algorithm or trying to put together a project, exercises to try and anonymize data, or hash it or obscure aspects of the information to make it not personal. And I guess the thing that I would underline from the various projects and legal expectations that are emerging and exist is that you can't take such a restrictive view. Again, this last bit here on the slide, if you can connect the dots with other bits of information, it will still be personal data. So data protection laws also have principles. These principles essentially do not ignore that people like you need to make trade-offs to be able to work effectively and create products. So one of the first principles that underlines data and privacy laws is fairness. Data should be used in a way that's fair and in accordance with the reasonable expectations of the people that it impacts, so all of us. And in practice, that means being transparent, telling people why and how a system will process their information. And I'm sure some of you will have questions about how you do that in practice and whether or not that information is really useful, particularly in the types of work that you're doing. But in short, the legal level, I would say, is ensuring that there aren't any nasty surprises. Again, to this trust point, people should be aware of how their information is being used. And so your products and your systems should be designed in a way that guarantees and enhances trust. And this image here, you may have heard recent news about the online exam process at Dartmouth. It might be very similar to many of you as you proceed towards examinations, but it's very relevant for this principle of fairness. So the New York Times reported a case of a first-year student at Dartmouth Medical School, and they were on spring break in March when they got an email accusing them of cheating. The university had been using an online system during remote exams and had reviewed the students' online activity. And reportedly, the data indicated that the student had looked up course material during the test. And this student described the circumstance as one of the most terrifying and most isolating experiences of their lives, how their data had been used by a system that was created, to be fair, in order to prevent cheating. But the student said that they hadn't cheated at all. Now they face misconduct, marks against their record, and their dreams could be entirely derailed. But this same investigation by New York Times admitted that many organizations have started to install this software, particularly as we're doing the sort of remote working scenario because of the pandemic. Software that can use webcams to monitor eye movements, and also alert potential suspicious activity. But as many of you will know particularly, these tools can produce unfair and inaccurate outcomes. So in this circumstance, with research, it was identified that leaving other tabs open can automatically generate activity logs, which would suggest that a user is looking at content when they're not. That could produce an unfair outcome if the data is used. And so just to underline this important foundational principle, as part of your exercises when you're designing technology, the questions that you should ask is it actually fair to create this? Is it fair to feed data to the system that I'm creating? Because will that fundamentally undermine someone's rights? And there are other principles as well, some of which are up here now. And so, for example, one is purpose limitation. You shouldn't use data for one reason, say academic research, and then flip it and use it for an entirely different purpose. Because clearly when you collected data from someone for academic purposes, they don't necessarily expect that you're going to monetize it unless they've been told. And so this is one of the really important principles that underlines the laws that exist and are emerging. You've also got here the importance of minimizing data. So particularly if you're doing a data analytics project, hoarding lots and lots of information, particularly where it's personal that isn't necessary, will cut across the principles and requirements of the law. And there are a couple of others here. So making sure that data is accurate. So if someone requests for information to be updated, your systems would need to be capable of executing that. and also, of course, keeping personal information confidential. And so we'll talk about artificial intelligence in particular in a moment, something that I'm particularly interested in. But the laws are changing, and I think here, moving away from data regulation, I would say that there are sort of three global perspectives around how technology like artificial intelligence is going to be regulated. And so in the European Union, what I would say is that there's a shift towards more sweeping regulation that regulates high-risk uses of artificial intelligence, like social scoring or like subliminal techniques that can cause harm to individuals. That we'll delve into in a bit more depth in a moment, but these laws will not just be centralized in Europe. They will have what I call long arm reach, so they'll touch lots of different countries. And so if you're working in the US, you can't assume that the European rules won't be relevant. In the UK, I think it's fair to say that currently we're taking a more proportionate approach to the regulation of technology and the use of it. So we're seeing a lot more sectoral guidance. And so, for example, banks will receive guidance from the financial regulator in the UK. We have very good and detailed guidance from our data protection regulator, the ICO, as well. And in the rest of the world, you'll see that there's a lot more by way of ethical frameworks. And so taking these principles that we've just discussed, but making them more kind of an overall framework for people to work within if they wish. We're not seeing hard legislation in exactly the same way as we're seeing in Europe. So, artificial intelligence. I'm going to talk about this because obviously data fuels technologies like AI. But AI is novel ways that is increasing risks for society. And some of you may have seen the Netflix documentary, The Social Dilemma, which described classes delivered to very bright Silicon Valley students, people just like many of you today, I'm sure. But in these classes, the bounds of human psychology and how technology can be used to change behavior, a new frontier of tech development were explored, and how exciting for machine learning models to be trained in a way that allows people to connect more quickly. And we spoke very briefly about trade-offs, but there's a very viable business model here too, right? Because people get access to the content that they want, and in return, a company is compensated for that and for creating these platforms that bring people together and that connect them. And so these students graduated and they founded technology businesses that are so fundamental and intertwined into modern society. And I don't know how many of you work in user experience and designing technology and applications in particular, but I've been recently reading some research relating to the psychology of the infinite scroll. The habits that we all have when we pick up our devices and scroll through. And you may have heard of the work of B.F. Skinner. Skinner was one of the most influential writers in behavioral psychology and founded the theory of what's called operant conditioning. And very simply, Skinner's theory focuses around reinforcement and punishment. So when people laugh when you make a joke, you're obviously more likely to like them and tell more jokes because you think they're funny. They're approving of you and they're giving you attention. But when you don't laugh, hopefully you will move on. What really keeps us engaged in these interactions is that feeling of unpredictability, right? So it's not continuous reinforcement. When reinforcement is variable, we wait for those jackpot moments. So the moment that you're scrolling and then you see this exactly perfect content, that psychologically keeps you hooked. And in designing this technology, as I say, there's a very viable business model here. But what we're increasingly seeing, picking up on principles like fairness of these new laws and transparency, is that whether or not people are conscious of these designs, it's important that legally and ethically, the people that make this technology actually think about the risks and how to mitigate those risks for people, because For example, as you will know, many platforms are starting to implement controls for the sort of psychological harms that people can have for spending too long on an addictive platform. And what the law is saying is that, you know, an algorithm, if it feeds content that can be harmful, even if it's legal, and does that so consistently, you know, that's something that needs to be regulated. That use of technology needs to be guarded. If technology will exacerbate mental health issues by reinforcing messages that aren't innocent or that are harmful, that needs to be regulated as well. And so the question that, you know, as a lawyer, I work through, but also as a person, I think about very deeply is, you know, who's responsible for preventing these harms? Is it us and as, you know, advisors working with businesses, or is it the designers of products when they're coming up with new theories and advanced technologies that don't currently exist? And also, you know, what happens when societal expectations differ? And so a very valiant attempt at addressing this is coming from the European Commission. There's a proposed draft AI regulation, which is very recent, and it's the first AI-specific law. You know, tech addiction and disintegration of mental and physical health has sparked the urgency of regulatory intervention and doing something to actually address the high-risk uses of AI. So, you know, as I mentioned, many of you would have read about ethical initiatives, principles that companies release. What this regulation is doing is proposing hard rules to sort of gather and synthesize all of these principles, like fairness, like transparency, like accuracy of data, like privacy, as they apply to the use of high-risk AI technologies. I think it's fair to say that Europe isn't proposing to demonize or to restrict the creation of AI systems at all. And we'll go through this pyramid in a moment, but as you'll see at the bottom, there's a whole category of AI systems where the proposal is essentially saying, you know, AI systems that aren't going to pose harm, we don't need to regulate in such a restrictive way. However, right at the top of the pyramid, there are some use cases, which we'll go into in a moment, which are so risky that something further, something beyond is required. I think what the Commission have said is that whilst most AI systems will pose low to no risk, some do need to prevent undesirable outcomes. And so an example they give is, you know, where the opacity of an algorithm may create uncertainty and hamper effective enforcement of legislation, something further to protect people's rights is required. And so looking at this pyramid here, at the top, you have a category of AI systems that they're looking to regulate that they will prohibit the use of within Europe. So these are particularly harmful uses of AI that contravene European values. So for example, what has been proposed is a prohibition on the use of AI systems for social scoring by governments, exploitation of the vulnerabilities of children, the use of subliminal techniques. So just to take one practical example, if you nudge people through an application to encourage them to get a financial product or a service, and it's done in a way that's subliminal and deliberately designed to cause harm, that will be something that will be prohibited. And another interesting area within this list is the use of live remote biometric ID systems. So that's basically the use of law enforcement surveillance. And so, for example, all of the sorts of cameras in the streets, obviously, you know, that is particularly high risk and could violate many rights of individuals. Then you've got another category below, and this is what's called the high risk category. And in very broad terms, this will include a limited number of AI systems that are defined in the proposed AI legislation. That list can be updated, and so again, it's not the use of the AI itself, it's the risks that can arise from these specific use cases. So those include the use of facial recognition technology, the use of AI in recruitment, and importantly, the use of AI in things like the judicial system. Obviously, if you use AI systems to make decisions about people's fate and as to whether they go into prison or not, it's really important that you have protections around that. And then at the bottom, you've got limited risk AIs. So for example, chatbots, where the law is proposing to impose less obligations. So for example, transparency towards people like us, if we're interacting with an AI system, just so that we know what we're interacting with. And there are some provisions around deepfakes as well. I really welcome this risk-based approach as a lawyer, and I would think that as computer scientists and technologists, you would as well, because there's a risk that you over-regulate this area, and so you capture many systems that don't really pose a risk, but are absolutely integral to technology systems that we all need to function as a society. And just thinking about what these obligations will look like, because again, this will help inform your understanding and decisions around what you might need to be thinking about in the next couple of years. I think the requirements for providers of AI systems, so the people that design, sell, or distribute them as well, will be bucketed into various categories. So one is governance requirements. So that's making sure that there's human oversight, proper training data, and actual rules around the design of an AI system. Interestingly, there's data governance requirements, and that's really important because this is about actively debiasing data sets. And we'll talk about this a bit in the context of facial recognition technology in a moment. But one of the ethical issues that I often see is that technology doesn't actually respect or take into account the importance of having good data, because if you feed bad data in, you'll get bad output. And the law is giving some more guidance around what is expected legally around data sets. And then there's also, perhaps a little bit boringly, but again, quite importantly for you to be aware of, is documentation and record keeping. So more than ever before, actually keeping records, logs, etc., of how a particular system is operating will be really important. There are less obligations on users of AI systems. So for example, if you're a company that's procuring in AI, say for recruitment purposes, there will be less obligations under this law, but that would oversimplify the importance of the regulation for everyone that is using AI, because effectively, how many organizations really know what complex AI they're using, what simple AI they're using, and so forth. And so this is something that I imagine will, be a complex and long thought out process for people to be able to fully understand the implications for design, but also legally. I think another area in AI that's of interest to all of you is AI explainability. And so I've mentioned that there's a patchwork of rules and laws that govern use of technology and data. And some of these rules were created for more advanced technologies before they were actually a reality. And that means that their protections are sometimes not fit for purpose. They weren't really designed to regulate use of technologies that obviously didn't exist. One of the laws that applies to AI right now is the General Data Protection Regulation. I'm sure many of you have heard of it, the GDPR. It's a law that came into effect in 2018 and gives people rights to privacy, for example, to access information that organizations hold on them. But one of these rights is relevant to designing and using AI. And that's the right for people not to be subject to solely automated decisions, including profiling, which in short, legally or have significant effects on them. We can delve into that, but your design or input of data into a process can be a solely automated decision, even if the decision is carried out by an AI, say a machine learning algorithm. So, for example, a decision that may impact someone significantly, returning to what I said before, is nudging someone to gamble or targeting high-risk financial products to vulnerable parts of society. And so thinking about the law when you have a really great idea and understanding these expectations is really useful, because actually a lot of the time you can find ways to make it work. And of course here, to the point about ethics, it's a good thing. to be able to interrogate and go through your plans and think about whether they accord with, societal norms and what the law expects. But I do appreciate entirely that it's very challenging to explain, for example, how a black box algorithm works. What if it can't actually even be fully understood or explained by the person who designed it? And what are regulators and governments expecting in terms of explanation? There was a really interesting paper, I think it was last year, from the US National Institute of Standards and Technology. And it goes through basically the different types of explainability. And very broadly, I would say that there are two categories of AI explanations. The first is process-based explanations, and the second is output-based explanations. So a process-based explanation basically is when you're describing a system, how it's been designed, essentially so that the reasoning behind a specific decision is made more transparent. And an outcome-based explanation, and I think this is what people often think applies when they're talking about AI explainability, is when you have an explanation of why a particular decision has been made by an AI system. So this might be an explanation of why you've seen a specific advertisement on social media, why a credit application is accepted or declined, or why specific TV content is delivered to you on an app. Process-based explanations are important for audit purposes. And what the law is saying increasingly is that auditability and being able to track how an AI system makes a particular decision is really important. A process-based explanation might explain the processes implemented by an engineer to design an AI or debug a system. And in that context, clearly the detail is going to be much more extensive and require a longer response time. And so you'll see here at item 3, you'll have a very detailed explanation, but it will take a longer term to have a response. Something like an emergency weather alert is going to be much more simpler and require an immediate response. And so it's really important to recognize that context is absolutely key. Not every sort of explanation will be what is required by the law and also the people that are working with an AI system. And there are various different stakeholders to be involved, and explanations will vary according to the consumer. So some explanations will be really simple. Others will be really detailed and could require training or expertise to fully understand. And I suppose the takeaway is when you study and create artificial intelligence, you will need to be thinking from the outset who will be impacted by your product or your tool. And so if you're producing high-risk AI, because of all of these regulatory requirements that I've just mentioned, the board of a company or your customer, if you're making a product to sell yourself, will need explanations of the risks that can be created by your technology to be able to make their own assessments of the trade-offs that may apply if they accept and use the tool. You'll also need to think about what customers expect and what kinds of data you need to provide to regulators, for example. But on that point, for a regulator, you'll need to think about the sort of complex technical workings of a computer system, yes, but a regulator will be more interested in how decisions were made throughout the business and throughout the life cycle of the use of AI. I think the most important point around explanations of AI is inclusive dialogue. And so you see all of these different stakeholders here. Depending on the type of tool, it's very important that different stakeholders are involved in the discussion, so it's clear what explanations will be expected of you and when you need to provide them. There's no hard and fast rule, but it's certainly something that is being interrogated and thought through very deeply at the moment. So what does this mean in practice for you? I think there are 3 core pillars to bring all of these legal requirements to life. I think the first for me is drawing bright lines. And so you should be very careful about data provenance, where data comes from. Also, you need to be able to explain why it's appropriate to train an algorithm in the way that you propose, and document what trade-offs were considered and why. Because if you make a decision that could cause a significant risk to someone, you need to be able to show that you thought through that risk and it was justifiable. Returning again to that fairness principle, is it fair for you to use data and to create technology in this way? Again, returning to documentation, regulators and rulemakers are basically saying it's really important that documentation of all these decisions is available, that logs are kept in terms of how AI systems are using as well. And that needs to be presentable in a way that's understandable. And you will push up against issues here because what you understand will be very different from what I understand. As a lawyer, I certainly will not understand all of the detail, but essentially I don't necessarily need to. And so that's why it's very important to have these groups where everyone is aware of the different contexts in which these explanations are required. I think the second important point is moving away from theory and actually thinking about how you put your software and AI through strict methodical tests. So that's not just user acceptance testing, but it's also identifying which AI systems that you are creating will pose the highest risks. And so looking at this AI regulation and looking at the list will be really important because then you know the territory. But to be honest, it's also having a gut feel. So if you're creating something that you know will cause potentially distress to vulnerable people, of course, it's taking a step back and thinking about if there's a better way to design technology, and also making sure that there's a better way and a good way to explain how the technology works to somebody. All of this together is really useful for helping sure that people understand and can trust the technology that's being created. And one of the areas where that trust is somewhat eroded, particularly from a legal perspective, and is really exciting from a technology perspective, is facial recognition technology. And so I thought it would be great to talk through some of the legal developments in this area, and also some of the practical things that you might be thinking about. So FRT, facial recognition technology, is obviously ubiquitous. It's so useful, and potentially poses some of the biggest risks to society at the same time. The really obvious things are, the risk of unfettered surveillance of public spaces by governments and police forces, which could contravene fundamental human rights. I find this one of the most fascinating areas of law because it so visibly impacts public authorities, private companies, and all of us. We are subject to the use of facial recognition technology, whether we know it or not, every day. I walked into the office today, and there was a scanner which scanned my face, very elementary technology. But thinking through this before this presentation, I was sort of like, what legally is important with these sorts of technology. And that's really important because the value of this by 2024 is meant to be $7 billion. So a lot of you will be working in this space, and all of these legal and ethical risks that I've just mentioned need to be built in if we're going to have technology that works, not just for the people that are creating it, but also the people that are subject to it. So there are tons of use cases for facial recognition technology, which are really exciting, and some which are really useful. So for example, the use of FRT for access control and security systems has replaced just basic fingerprint scanning a lot of the time, as I just said. You've got electronic banking identity verification, which many of us use every day, but it's also starting to be deployed in different and new contexts. So it can be used to monitor crowd control, to search for criminals, and also help people spot emotional cues. And so, I've seen facial recognition technology, and I'm sure you have as well, used more in the recruitment context. There's what's called sentiment analysis. So using the technology to estimate the sentiments of the people interacting with it. I don't know how many of you have seen FRT applications that guess age. A few years ago, I stood in front of one and it genuinely aged me by 15 years. And I was in distress I just didn't need at that time. Anyway, we often make a conscious use to use FRT because it's considered to be secure and efficient or even fun. And of course, when we make these conscious decisions to use FRT, that can still raise concerns from a data protection, a privacy, and an ethical perspective. So FRT can still be problematic when it's operating within the parameters of all of these laws that we've just discussed, because right now, it tends to be less accurate on individuals with darker skin, for example. And going back to the point that I mentioned about representative data sets, this is one of the areas where the law is making sure that fairness is applied, but practically people need to be making sure that they apply these principles to what they're designing to make the technology more fair. So, I mean, there are benefits and risks to facial recognition technology. So there are three here. The first is security. It can strengthen the security of the buildings that we're in and our private premises. Facial recognition technology is so efficient. You can instantaneously verify someone or spot people in the crowd, and you can save human work, increasing efficiency. So in research that a colleague did recently, we found that an airline claimed that their facial recognition system would shorten boarding time of an airplane of 270 passengers by around 9 minutes. And so this ends up meaning that I think around 195 hours are saved over every 24-hour period. And commercially, this is really good for businesses and people because the efficiency savings can then be passed on to the users and customers. And I guess the last is also scale. We've talked a lot about the human-centered approach for technology, but algorithmic systems don't suffer from human fatigue or destruction. And so they're often very attractive where human work can be inaccurate. There are obviously risks. So there are a couple listed here. So privacy, inaccuracy, and importantly, power imbalance, returning to that first concept that we discussed. So there's a concern that a disproportionate amount of power lies in the hands of developers and operators of facial recognition technology. Because if you create a system that's used to verify people, or it's used to be able to gain access to essential services, if the developers and operators haven't calibrated and designed that technology properly, the power for those people that just have to get on with it and use it is reduced. And so again, in terms of ethical responsibility, returning to a question I made before, the question is who should be responsible for taking ownership and making this work? And to take one example, Joy Bulamini, the computer scientist and founder of the Algorithmic Justice League, was working on a project using facial recognition software. The software couldn't see Joy's face, but had absolutely no issue seeing lighter skinned collaborators. And Joy put on a white mask and the system instantly recognized the facial features of the mask without issue. And I reflect on this personally quite regularly. I recently read about the government technology in the UK that you use where you get a passport. And the FRT, when it sort of tells you whether or not your photo is accepted, or you need to move your head and twist it in a certain way to be able to make sure that your photo is approved. I have experienced that it tells me that even though I followed all of the rules, that my photo is rejected. And in part, that will be because of the design of the technology. And I think what two writers, Catherine D'Ignazio and Lauren Klein, observe in their book Data Feminism, thinking about Joy's case, is that when you dig deeper into the code and look at the benchmarking data that these systems use, it was found that there was around 75 to 78% male faces and 84% white faces, that benchmarked how the FRT made decisions. And ultimately, in work with the computer scientist Tim, it was found that non-white women were 44 times more likely to be misclassified by this technology than lighter-skinned males. And what D'Ignazio and Klein call this is the privilege hazard. It's the fact that none of the users, the coders, and the testers had actually noticed this when they were designing that facial recognition technology. And my sincere hope is that people are much more aware of these issues and the fact that in their design of technology, they need to actually implement a lot of what we are discussing as a society. But the law is now also making and reflecting these societal expectations. And so from an ethical perspective, you are the gatekeepers of these social and economic and technical awarenesses. And so it's a deep responsibility for all of us, but also particularly for people that are creating the technology to be able to apply ethical principles when they're making it. So I'll talk very briefly on human rights because I want to leave a little bit of time for Q&A. But human rights cannot be left out of this conversation, particularly around facial recognition technology. And from a legal perspective, this is where we are seeing cases being brought before the courts. So in Europe, there are rights under what's called the European Convention of Human Rights. The first is the right to privacy and family life. And there's also the right to freedom of expression and the right to freedom of assembly. I remembered I promised not to talk about articles at the start of this presentation. I was about to list them off. Anyway, there are fears that people may be discouraged from showing up at protests or posting images on social media due to fears about misuse of their facial identity, say. And there's also this risk that the police, just like companies, might use technology in a way that's intrusive and discriminatory. And so these fundamental rights do apply to all of these uses of technology. And there's an importance in recognizing, again, and designing and creating facial recognition technology or other technologies, to be honest, that these human rights do apply. And it's not just from a legal risk perspective, again, from an ethical point of view, how will you make sure that these human rights principles, these rules, these laws are adhered to? This applies, alongside the emerging regulation. So we've talked about the AI rules. And I think what's really interesting is that we're going to see a shift to specific regulation of facial recognition technology in a way that doesn't quite exist. And so the draft regulation, finds use of real-time biometric identification systems for the purpose of law enforcement, particularly high risk. And because it's so high risk, the proposal is that that will be prohibited from use, subject to very limited carve-outs. So, for example, the prevention of terrorism and the protection of threats to the life or physical safety of people. But, facial recognition technology that isn't live. So we've talked about, FRT used in the context of recruitment. Earlier, we talked about it in the context of exam monitoring. There will be a need for that to be regulated within the high-risk category currently. That's the proposal. And so there will need to be much more by way of documentation, much more detailed explanations towards users of these FRT systems about how they work. And all of this, again, going to this point about power, is readdressing the power balance. So I think, just to end, what can you do? It's one thing to say that there are all these rules and all these laws. There's lots of excellent work, which we haven't explored in much depth, that provide ethical frameworks for coders and ethical principles for developers. But, what are the things that are expected by the law specifically? I think one thing that is very useful is risk assessments. And so when you're designing new products, systems under existing laws like the GDPR, there's mandatory requirements to carry out data protection impact assessments, where there's likely to be a really high risk to, not necessarily really, a high risk to individuals' rights. And these assessments identify legal risks. Depending on how you design them, they can identify ethical risks as well. And all of this is good news because it helps you design technology that reduces the risk of bias, reduces the risk of unfairness, and therefore adhering and complying with these legal principles. And so working through these risk assessments, and when you join a company or you're creating something on your own, having a framework that you can work in to be able to identify risk is really useful. We talked briefly about testing and audit. Data sets used to train technology should be made available, in some circumstances to the public, and independent evaluators who can actually validate the performance of the data sets and the technology that is used. But really importantly is, users and developers should also always be conducting ongoing tests and examination of the performance of tools like facial recognition technology, just to make sure that the models are, working in accordance with what was intended. And I think the last point I would reflect on is, with all of these sorts of projects, it's really important to, draw the bright lines. I mentioned it very briefly earlier, but having and being honest and about where technology will and will not be used by you, where it will not be designed by you, is really important. I think everyone has their own view on what is acceptable and what is not. But what you will find is that the laws have their set of principles that reflects what society as a whole expects. And being aware of these and working within these frameworks as well would be incredibly important. So with that, thank you very much for taking the time to listen to this talk today. I hope it sparks some thoughts about how the law will apply to what you do, and would be absolutely delighted to continue this discussion with you in the future. And I'll pass back to Luna now in case anyone has any questions that they want to talk through.
Right, thank you ever so much, Herbert, for that brilliant talk and the brilliant PowerPoint that you put up. It's probably one of the best presentations, the prettiest one I've seen this term. Don't tell the other speakers, but that's the truth. Right, so editor, I think we have some questions gathered on a Google Doc. Could we have one of them, please? You're still waiting for the questions. Aha. What is the best way to use AI in the legal field? What are some examples of AI that is being used in the legal systems?
Yeah, I think in the legal field, definitely where I work, one of the best ways is taking the work that is very time consuming and not necessarily very interesting, to be able to be more efficient. And that's particularly important. For example, if you are doing a transaction and you want to diligence a business to be able to work out whether or not to buy it, that is a very time consuming work. And, we use tools to be able to accelerate that, so we can focus on more complex work where actually the human element is so much more important, where you're making decisions about risk, where it's quite concerning that you have people that are properly informed about the legal environment to be able to make a sensible commercial decision. So I think that's one area. And then we spoke a little bit about the use of AI in the judicial system as well. And so there are certainly massive risks around that, particularly where it's decisions that could threaten somebody's livelihood. But also there are ways that you can simplify processes, like going through lots of court bundles and documents. And so lots of good use cases.
I think definitely this is applicable from science, that you always use AI to automate the repetitive tasks rather than the ones that require human input. Right, I think we'll move on to the second question, if that's possible. In what ways might the Internet of Things affect our privacy? And how can we use it to enhance our own lives?
Yeah, good question. I mean, the Internet of Things can affect our privacy because if all of our devices are connected and it knows where we are all of the time, I think the risk is tied to cybersecurity in particular. And so if people know where you are, and that information can be hacked, The privacy is one point, but then the risk to our own lives is particularly problematic. But also, just generally privacy, the connectivity of different devices together is particularly concerning. Sorry, the questions jumped off. There was a second part there.
Can we have the question back? How can we use it to enhance our own lives? I think that's probably more scientific, but
yeah, I use it to enhance my own life by having my Alexa connecting around the house. And I was reading about O2O. I don't know if anyone's aware of this, but online to offline marketing. So for example, you go into a shop and you can order stuff on a device, and by the time you get home, it's already at your door. Like, it can enhance our lives in incredible ways. But those use cases have to be sensible, and they have to be limited to things that aren't, going to undermine these rights like privacy, as whoever's asked this question quite relevantly picks up.
Okay, I think that's very true. I feel like I am a bit of a technology noob who doesn't know much about Internet of Things, do not have an Alexa, doesn't know how it works, but I'm sure it helps everyone in different ways. So,
I love Christopher Farris's comment, dang, it's like the sci-fi movies in real life.
Well, we're moving towards that, so good thing or bad thing, I guess we'll see. Right, we'll have the third question then. A model is as good as the data used to create it. How do you ensure that an AI was trained on a balanced data set? There's also a tiny bit at the bottom, which I will attempt to read. And how would you define a balanced data set for the purpose of regulation and assessment?
Yeah, I think you have to start by understanding what you're going to be using the AI for. So if you're using, facial recognition technology that's enabled by an AI system, to make sure that the data set is properly representative, it obviously has to reflect the society in which it's being used. And so if it's a government tool which is being used for the entire country, you have to think about what data sets are being fed in. I think one, example of this is the use of algorithms to be able to identify people who are likely to commit crimes. I think it was in the US, an old data set, which said that a particular bit of the society was more likely to commit crimes, was used. And that just wasn't accurate. It just didn't reflect what was happening in practice. And so it's before, putting together a data set, you have to really think about who you're trying to use the technology towards and whether it's fair and representative.
I think just the example you used really highlight the importance of continual maintenance of this balanced data set. Something that might have been balanced a few years ago or maybe a few decades ago could perhaps nowadays be no longer balanced anymore.
Yeah,
so
certainly.
Right, fourth question. I'm sure we have many to go through and we have a bit of time left. So what are the responsibilities of the developers of AI? So this is probably the people who does the actual science, does the actual programming, and then the second bit that popped up, should they team up with legal professionals to make sure the technology is used safely and within current laws?
What a good question. So what we advise and work with clients to work through is this importance of making sure that the legal professionals are linked in with the developers, the product designers, because if you don't do that, often what you have is you have a system or a tool that's created, it gets the end of a process, and then it goes to a legal department who say, these laws apply, and therefore you can't have this tool designed in the way that you want, which is an absolute nightmare. And often, lawyers want to work with the business and people who are creating things to be able to make technology that is, positive and useful. And so 100% involve the legal team, involve the developers, involve people that are involved in policy, for example, so that they understand what is emerging and what's coming down the pipeline as well. And so there's a real importance to involve all of these different stakeholders, like that slide that I put up earlier.
Yeah, I think communication is key, especially in these multidisciplinary areas where you would need expertise from various different people. Right, we'll have the next question then. According to you, why were COVID tracking apps so unpopular in Europe, despite the clear privacy regulations that went with it?
I think it's because of this point that, I started talking about, at least for me, it's about trust. And so it's one thing to, go out and have all of the right notices, have all of the right disclosures to comply with the law. Often you'll find that there's like reams and reams of information, the really long privacy notices that you often see when you go on websites. The question is that really helpful? Because does that give anyone the feeling or sense that they're in control and that their data won't be misused? And I think I am a lawyer, yes, but one of the things that we notice is that there's a really important point about making sure that you bring people along with whatever a technology proposal is. And so you explain in really simple terms what you're trying to do, why you're trying to do it, and then people are more likely to trust it. I think that's it. Fundamentally, it's finding ways to engender trust in what you've prepared and created.
I think as a consumer, I would definitely agree with that, because I am sure that everyone knows that no one actually reads the T&Cs at the beginning of an app. You just scroll through endless and endless lines of text and decide, okay, sure, I'll consent to whatever this is, without actually understanding what the implications might have been.
Yeah, exactly.
So I think that's definitely very key, that in the future, if someone could simplify the process and highlight the important points, I think that would be much appreciated. Right, I think we have a question from the audience, which we'll pick up. Would you mind, Lorenzo, putting that, clicking on that comment, and we will discuss that next. Right, it says, as an educator, how do you see AI integration into the public education system for the upcoming generations?
Yeah, it's interesting. So I think I'm just thinking in the sense of the UK, one of the things that I hope will come in our upcoming national AI strategy is the importance of public education about AI to engender trust, like I just said. And so a lot of the consultations around this are saying that upskilling and explaining technology will help mitigate lots of these risks, because as lots of you will know much better than me, when people say AI, they imagine scary robots and things that are going to take over their jobs and make them, redundant. But actually, if they understood what AI is, that would be really great. And also, to the point that I was making about regulation, distinguishing and teaching people about what is high risk AI and what isn't will be really useful. And so I think integration into the public education system will be really useful for upcoming generations. And I think it will also empower people to be able to make better decisions. And so, disinformation on platforms, for example, is one area where if people understand, when something is more likely to be content that's harmful, and you'll see now there's lots of kind of notifications and things like that, this education will help engender trust. And so there are different ways to be able to make sure that people understand what's going on.
Right. I think it just marks how important it is to drag the public along with us, people who perhaps might not be so engaged in the conversation as developers or as legal professions. But the fact that it does imply something about their lives means that they have been involved in the conversation as well. Right. I think we'll have time for perhaps 2 more questions, and then we'll have to draw to a close. Right. The penultimate question, please, then. Would you say that the current regulatory inventions are lagging behind the speed of technology developments?
No, I would say that the regulators are intervening, not necessarily so much in terms of enforcement at the moment, because there's an appreciation of the need to allow for businesses to innovate and develop. The intervention, I think, right now is listening to people that actually design technology and understanding what the risks are so that they can create regulatory frameworks that work. And so, I talked about a draft EU regulation. That's the sum of years of discussion and years of consultation with people that know much better than the lawyers that are writing it to make sure that it's fit for purpose. And I mentioned also the sorts of regulatory guidance that's emerging. So, you've got competition, consumer protection authorities that are, providing people with lots more guidance about the importance of explaining algorithms and understanding how algorithms work from a competition perspective. You've got financial regulators who are doing that for the financial sector. And as I say, the data regulator here is so active in the UK. to provide guidance to businesses, for data analytics, for example, and explainable AI. And so making, I guess, the regulatory intervention currently around a lot of this is helping businesses rather than trying to enforce against them unless the risks are so apparent. But there's not a lack of appetite for that. And so, as many of you will know, there's been a lot of enforcement around data protection and data breaches and cybersecurity. And so it's trying to draw that balance, I think.
I think I definitely agree that there's a lot of effort that's going into this area, because we know that making regulatory interventions is by no means an easy feast. And lots of things must be taken into account, and that means that it will take some time. And at least the good news is they're communicating with people who's actually doing the science. So whatever that's been put in will actually reflect what needs to be done in the sector. But we'll have one last question, and that will be it for today. You're still hoping it will appear soon? Yes, here it is. Do you think that public awareness of the issue of AI risks is important in encouraging ethical use of technology? I think we've touched on this slightly, but perhaps you can just draw somewhat of a wrapping up statement from this question.
Yes, in short, I think that if people don't know how technology is used and what AI risks are, then they can't demand things of organizations. But also from an organization's perspective, if people aren't aware of the risks of AI, they may overstate them. And so it's this kind of, it goes to whoever asked the question about the importance of education to the public. I think awareness of the risks and also where there isn't a risk really is really important. So education around that is the key.
Right. I think that is all the time we have for today, and I'll wrap up here. A massive thank you to our speaker today, Herbert, for having time and giving us this speech, this fascinating talk. Thank you to everyone tuning in from the audience, as well as our committee members, to make this possible. Next week on Thursday, we'll be hosting the rescheduled presentation on optical illusions by Professor Clayton from Cambridge. Hope to see all of you there, and enjoy the rest of the evening. Goodbye.